Good morning, everyone in Business Law 2. I thought I'd put up a quick video, and it is going to be quick, about principles of insurance. It's really an introductory chapter um, really could have been combined with chapter 36, and that's the more meaningful substantive laws related to insurance, and could have been really incorporated too. But it starts off with the principles of insurance. A lot of its vocabulary in this chapter. The book does a really nice job. It starts off with what an insurer is, or an underwriter. That's basically the company or entity that is going to be the guarantor or the indemnifier for any kind of loss that's recognized in the policy. And what is the policy? It goes back basically to the fundamentals of contract law. You can contract for most anything as long as it's not illegal or against public policy in some fashion. So you can insure against all kinds of losses. I'm always thinking about property, for example, real estate, because my insurance policy, I don't know if it's right here, I think maybe this document right here. I recently bought this home in the past year or so, and I took out a mortgage. And when you take out a mortgage, the mortgage company, and this relates to a later chapter anyway, so it doesn't hurt talking about it, the bank, the mortgagee, they have an interest in the property too, because if I don't pay the mortgage, they want to foreclose and take the house and sell it and get their loan money back, is basically it is. There's two documents. One's the promissory note, which we talked about in negotiable instruments, and the other is the mortgage, the actual security interest that they would have a right to foreclose on, also a negotiable instrument. Now, because something could happen to the house, it could burn down in a fire, other events could, an earthquake might happen, and the house could become totally valueless. All that would be left would be the land. And so the bank wants me to insure the property for their protection. They say it's for my protection too, but it's really for their protection. And so that's what we have as a policy of insurance on the home that protects me as the primary beneficiary, but the bank also remains a beneficiary as well. So say I have X number of dollars of equity in the home, and the house burns down and it's a total loss, I will be paid the proportional share of the policy of insurance after the bank is basically paid off for their indebtedness, their loan. And so who's the insurance company? Whoever sells the policy. I think I have something called Andover Insurance or Merrimack Fire and something. I don't even know what it's called. A lot of people think of their agent as their insurer. I go to McCaffrey down the street or something like that. That's an agent. They go out, remember from previous chapters, what is an agent? They go out and negotiate contracts on behalf of third parties. And so I have a local agent. It's McCarthy Insurance, and they brokered through with me to get a policy of insurance at home. I am the insured, or some people call them insured, but I'm the insured. The insurer is not McCarthy. They're just the agent. The insurer is, in my case, I think it's called Merrimack, Andover Merrimack, something like that. The policy is the policy of coverage, and it's going to have a contract. And it's kind of like things that won't be covered in loss. Sometimes it's hard to get flood insurance in some areas, and they say that's the one thing we won't cover you for is a flood, because maybe you're in some kind of tidal area right next to the ocean or something like that. Or if you are going to have flood insurance, it's going to require what's called a special rider, an added feature to the standard contract that might cost a lot more money. Because think about it, they're not going to want to give you coverage for a risk that's very likely to happen unless you're willing to pay a lot of money. The beneficiary, that's usually the insured, but not always. In my case on this house, I am one of the beneficiaries, but so is the bank. So sometimes they're surprised. But a life insurance policy, I have a life insurance policy on my life. Who's the beneficiary? Not me, because if I die, can't give me any money. It's my loved ones, my family members are the beneficiaries of my health insurance. Beneficiary is who it goes to. These go back to third-party contracts from Business Law 1. Usually third parties don't have any standing to sue over a contract, but they do when the contract was designed to benefit that third party directly. Policy, again, is the written contract, and that's important because every so often, I used to do a fair amount of insurance claims. I shouldn't say fair amount, enough that came up that I have some familiarity with it. Now, we had one case that was directly involved with me, again, not only as an attorney, but as a client. We own an old building, and it had a boiler system in it that heated an extensive area. There was sort of multiple buildings in one, partitioned, and the boiler went. And it was like a $30,000 or $40,000 replacement cost. And so I called the insurer, but I'm glad I played smart. Before I called the insurer, I looked that they didn't cover basically the failure of the boiler. It had to be something like a combustible event that was outside of just basically normal wear and tear. Unfortunately, it was that, so there was coverage. But sometimes people think, oh, geez, my oil tank just blew up in my house. Oil went everywhere. It's a huge mess. I had to call some kind of environmental cleanup team. It cost a fortune. Let me call my homeowner's insurance. Guess what a lot of people don't have in their homeowner insurance, or they don't pay for it because they think they can save a few bucks, is coverage for oil tank spills and things of that nature. And so there's a lot of exclusions on a policy. How do you know? Look at your policy, read it, and if it's something you want covered, usually most of those terms are negotiable, like flood insurance if you're, if that's something that you're very concerned about. I think I was watching The Simpsons. I don't know if anybody here is a fan of The Simpsons. I know it still airs. I don't have cable anymore, so I don't watch it as much as I used to. But I think it was The Simpsons. At one time, Homer Simpson was about to go bankrupt for the multiple time, but he were looking at his policy of insurance, and he had some kind of, was cloud insurance, some crazy uh, um, tsunami insurance. He was nowhere in the ocean. He had all these kind of coverages that are completely irrelevant, not needed, and he was paying heavy premiums for it. And the things that were more likely to happen, he didn't have coverage for, like like lightning and fires through accidental causation and things like that. The premium, the face of the policy is the maximum amount they'll pay, and sometimes there's can be terms that it can fluctuate, meaning it could be either X number of dollars or the replacement cost, whichever is less. You've got to be careful about that language to make sure it's something that benefits you the most appropriately. Premium, that's what the insurer pays. Sometimes you can pay a lump sum, pay X number of dollars, going to cover me for a year or a number of years. Most of the time, people pay either yearly premiums or monthly premiums to keep the policy going. I know my car insurance, I have a yearly policy on my car, but I pay premiums every month. I have it amortized out because otherwise, my family has 4 cars and it's fairly expensive to kind of lump that in one payment. So although we have a yearly policy, the policy is paid for in a monthly fashion. Those are called premiums. Risk or peril, what's actually covered? That's all it means, risk or peril, because some things aren't covered. And that usually shocks people, what isn't covered. I forgot what. I knew I had one that was pretty interesting that the person couldn't believe it wasn't covered, but it wasn't. An insurable risk, danger covered by the insurance. Some things just aren't covered at all, which relates to the risk or peril. And hazards, factors that contribute to the uncertainty. Then a rider, that's an add-on to the standard policy that you want to add an additional thing to it. And then the binder. Sometimes you come in, like when I bought this house here, I remember the day I bought it, I wanted to have a binder, meaning on that moment, although the whole policy might not be written up and all the details, there's sort of a brief bridge contract almost to make sure there's coverage for the rudimentary aspects of the policy on that very moment. And so sometimes when you go buy a car, you're at the dealership and you of course they don't want you to leave unless you buy the car that minute or that day. And you want to drive, they want you to drive away from get plates. It goes, oh, we'll have a runner go down and get plates. Whenever I get plates, you have to get a binder of insurance for an insurance company. All a binder is sort of that temporary policy that will merge into the whole policy after some details are ferreted out. Like when I bought this house, I got a policy of insurance the day I bought it. But within the next month, in order to formalize the more formal policy of insurance, they wanted an inspector come out and look at the value of the home and the street and make sure there wasn't like any, do I have a big fire pit up against the side of the house or something crazy that causes what? Increased peril, and they're going to make me remove it. They put a lot of things in the policy anyways. They're supposed to store chemicals in your garage. You name it, the insurance company wants to limit coverage, and that surprises people sometimes. I don't know if we're going to get too much in this chapter, but in the later chapter, it's in here about a warranty. Sometimes you put in a warranty, which is an overt promise. They have certain promises. You have certain promises. A promise to do or not to do something to comply with it is a type of warranty. That's all a warranty is, a promise. It's going to live up to something. Well, sometimes you make a promise that you're not going to have a wood-burning stove in your home unless you get it inspected by the town building inspector or something, or you're not going to do it at all. And you may not think about that later on, or you might have the policy for a long time. You go put a wood-burning stove in your house, you have a fire, and if that's the causal factor in why the fire occurred, it might void coverage because you breached a warranty. Very important to understand all the limitations in policy. It's all contractual. And some of the things that legal aspects of insurance company concealment, that's knowingly lying about something. They go get a policy on something. A person is the easiest example. Say, I know I've got some serious illness where I'm likely to die. a very strong chance. And I go out and take out a policy of insurance. So when I fill out the form, I said, no, I'm doing great. I'm feeling great. Got a lot of years left in me. That's concealment because it has to be a knowing lie. It can't be like, geez, I feel like crap. I haven't been feeling great. I just think I'm in a lull. That's not concealment. Concealment is I go to the doctor and I say, Jim, you've got stage 4 this, or you've got this other, your heart's, you've got congestive heart failure. You're not going to live the next year. And then I go and fill out a form and say, oh, everything's fine and dandy. As far as I know, I'm going to live another 30 or 40 years. That would be a concealment. Other is representation. It's basically a misstatement of material fact. You're lying about something in order to get the policy. That's obviously that's fraud as well. So misrepresentation of fact is fraud. That's exactly the definition of it. I don't know why they don't call it fraud. And warranty is again a promise that you'll do something in a certain fashion. Either both sides will. In their failure to do so, there's a breach of the warranty, and it may void the policy. Next one is subrogation. This is a real fun, interesting topic. I used to work on subrogation claims. So, for example, if an insurance cover covers my home here, and this is big old, it's not old, it's a big honking house, and say someone's driving down the road, and although it's not real close to the road, but say it was close to the road, and a negligent operator smashes his or her car into the side of my home, and hopefully no one's home, and the dog's out and the cats are out. Cats can stay, dogs out. And we all survive, but the house burns down, and it's a huge claim, right? And it's hundreds of thousands of dollars. Now, the insurance company will pay me the hundreds of thousands of dollars. It was covered. It was a covered loss. But they're now subrogating, meaning the insurance company has a right to sue third parties if they are negligent. But here's what's interesting. A lot of people think, like, what if it was my own fault? Like, I'm watching one of these stupid cooking shows, say, for example, and I'm a terrible cook, I'll confess right now, and I decide I'm going to go do some cooking, and I put some kind of oil in the wok, and it's this low flash point oil, so it's going to catch fire very easily. I'm clearly negligent. I'm very stupid about how I do it. I burn down the house. Now, is the insurance company now, after they pay the claim to me, can they now sue me for subrogation because I'm the negligent party that caused it? No, because that's the whole point of insurance, is to cover for negligent acts, not intentional. You can't burn it down intentionally and then claim insurance. That's a type of fraud, and it doesn't actually cover it. It's negligent or even grossly negligent acts that get coverage for. But what if it's a third party? And this actually happened to my friend, who's also an attorney. It's one of my favorite stories. He's cutting down these giant oak trees at his house. Not him. He hires a good friend of his who's an arborist, a tree expert. And it's amazing how they can make trees swing a certain way that, although they're pitched that way, they can still make it turn and move out. Well, I go over there, and it's after some of the trees are down, and one of the big branches didn't quite swing the way it was supposed to. It hit the back of his, kind of like a porch and a deck thing, and the house was pretty. He was going to do all kinds of repairs soon, anyways, but it did some significant damage. So he called up his insurance company. Insurance company came out, cut him a check for like 22 grand, whatever the repairs were, 23 grand. And so they did an investigation. What happened? He goes, well, we hired, Bobby Smith's, tree service. And so guess what the insurance company did? Well, they stand in now the shoes of the insured. And if a third party through negligence caused it, what would that original party have the right to do? Sue them directly. That's why you have insurance, so you don't have to go through that lawsuit stuff. But can the insurance company try to get subrogated, indemnified by going out and going after that third party? Yeah, it happens all the time. There's a whole industry that does third party claims, they're called. And I did that for a while for a law firm. I did a lot of third-party claims from an insurance company. They'd come in and they'd do an investigation. If the investigator determined that the loss was caused by somebody else's negligence, we'd go after that somebody else if they had money, if it was a company, a corporation, or they had insurance of their own. That's why there's a lot of insurance battles just between insurance companies. The sad part for my buddy was the guy that was cutting down the trees, thankfully he was insured, but it was his friend. So first my friend's kind of happy he's getting money because he was going to take down that deck and repair it anyway. So it's kind of not an intentional thing, but it's kind of like a blessing in disguise. So he's going to invest whatever he got, $25,000 in the new deck and everything. But then his friend goes, hey, I'm getting sued by Travelers Insurance Company. He goes, yeah, that's my homeowner's insurance, whatever. I'm just making up. I don't know if it was Travelers. And he goes, oh, wow. He goes, and so he called me up knowing I did insurance law. And I said, yeah, they have a right to do that. They're sort of a victim of a loss too. And if they're a victim of negligence, you can sue. And luckily the other guy, the arborist, had his own insurance policy. So that insurance policy sued that insurance policy because the one at fault ultimately should be responsible. And the one at fault ultimately was the arborist, but fortunately, the arborist had insurance. What if the arborist had no insurance? Well, you could still go after the arborist, the tree cutter, but what if he doesn't have a lot of assets and a lot of money? He could garnish his wages. It'd be a real nightmare. So that's subrogation. And then estoppel. All estoppel is a catch-all. It's everywhere in contract law. It's everywhere in life. It's even in criminal. It's everywhere. Estoppel is this equitable principle. You're just stopped from denying the existence or the lack of existence of something by your behavior. It could be related to fraud. It could be related to other misleading things, even if it's misleading without the intent to commit fraud. But if one party has reasonable reliance on the statements or actions of another party, that other party is stopped from denying the existence of it. So that's a defense to either paying a claim, or it could be a defense for denial of the existence of a contract. So if an insurance company reasonably led me to believe I had coverage on a certain date and time because I simply filled out a simple form, but they said somewhere in fine print or in other correspondence that was only an invitation to apply for a policy, it wasn't a policy at all, but it led me reasonably believe as an objective human being that I had a policy of coverage on that date and time, they'd be stopped from denying the existence of a contract. It's a kind of a catch-all equitable principle. It's tough to define because it's thrown out so often, but it's kind of a fundamental fairness under the circumstances that one party should be denied the existence or the non-existence of certain facts because you've led the other party reasonably believe the truth of a matter asserted. That's pretty wordy, but I think it kind of made sense. Subrogation, estoppel. And that chapter is fairly short, but the next chapter really segs right into the different kinds of insurance. And that'll be short too, because it's fairly clear and the book's well written on that. And I don't know how, well, I guess life insurance is pretty important for business law too, because you can have partners and key persons in your business, and you can actually take out a policy of insurance on them because you could be economically hurt if a partner or a critical player in your business loses their life. You will be economically harmed. And that's what we call having an equitable interest in the outcome. Otherwise, you just be gambling. Now, I'm going to take out insurance policies on these different people I don't even know or have any interest in. That's called a moral hazard. You can't do that. I'm already getting to the next lecture. I apologize, but be well, and hopefully this is a little bit helpful for the class.